Good morning, everyone, or afternoon. We appreciate you joining our discussion today. At a high level, the goal of this webinar is to unpack some recent developments specific to the cannabis taxation and the potential implications to the applicability of 280E. It'd probably be a good starting point to provide some introduction to those participating in the webinar. I'll start with myself. My name is Shannon, and I'm a tax principal with BGM CPA. I'm a CPA and CBA with over 25 years experience and almost a decade of experience working with cannabis companies. I've had the opportunity to work with both Nick Richards and Hannah King, and I'm grateful to both of them for the willingness to participate in this conversation. Nick and Hannah, would you both be willing to give a brief introduction of yourselves?
Go ahead, Nick.
Go ahead, Hannah.
Nick's refusing, so.
I'll go. I'll step in. My name is Hannah King. I'm a partner in Dentons National Cannabis Practice Group. Dentons is a global law firm. I think we're actually literally the largest law firm in the world. I've been practicing cannabis law since 2015, so a decade now. I represent hundreds of cannabis businesses across the country. I spent a lot of time over the years working really closely with our tax department, particularly Mark Lloyd, who's the co-chair of Dentons National Tax Practice Group, around 280E, and that includes work in the ESOP space as well as tax opinions.
Thanks, Calvin. Always great to work with BGM and you as well. We go back quite a ways, and it's been a really nice time working with you.
Absolutely.
Yeah. My name's Nick Richards. I'm a partner with Greenspoon Marder, a national law firm, not as big as Dentons, but pretty darn big. And I've been in the cannabis space for a long time. I had my first 280E audit client that I represented before the IRS. Shortly after I left the IRS, I was IRS counsel for about 11, 12 years. And then I left the IRS right when cannabis was kind of being born here in Colorado. And I had one of the very first 280E audits and learned about 280E and started talking about it and getting more clients. And today I'm in a much larger firm to handle the hundreds of clients that we have in the space. Really happy to be here today. 280 has been a really bad story for a long time. Maybe the last year and a half, the story got a little better. Tell us what you think. Looking forward to presenting today.
Yeah, thank you guys both for the introductions. And again, I just express my appreciation to you both for participating in this important and hopefully helpful discussion. So, Nick, I'll start with you with the first question. Maybe it'd be helpful to start with an overview of 280E. What is 280E? What specifically does it say? And who does it apply to?
Calvin, I got my code book out just for this moment. Okay.
Perfect lawyer move.
It's the larger size because I'm getting older now. I need that. So I'll go ahead and just read 280E. Okay. I think it might be one of the shortest code sections in the entire Internal Revenue Code. And it's important to know that it is a code section and not a regulation or a method or anything like that. It is the law. And what the law says is no deduction or credit shall be allowed for any amount paid or incurred during the taxable year in carrying on any trade or business if such trade or business, quote, or the activities which comprise such trade or business consist in trafficking in controlled substances, and this is a part that we're going to be talking about today, quote, within the meaning of Schedule 1 and 2 of the Controlled Substances Act, end quote, which is prohibited by federal law or the law of any state in which such trade or business is conducted. Essentially, what 280E does is it disallows deductions, but not cost of goods sold. And so cannabis companies pay, Calvin, I'm going to jump into your accounting world here. They pay tax on their gross rather than their net income, which is what we call income after cost of goods sold is allowed. It's a weird thing. It's a square peg in a round hole, and it treats different businesses differently. For example, our costs, professional costs for a cannabis business, may be deductible for a producer or a business, a cannabis business that grows or produces its own marijuana products and sells them in a store, but not for just a separate standalone dispensary. So it's really weird in our system the way that Section 280E works.
I think there's a
Yeah.
couple of interesting things about 280E. So first, I mean, Nick and Calvin, correct me if I'm wrong, but there's no regulations implementing 280E. It is a standalone code provision. And in addition to it, the history is a little bit interesting. I'll just mention it really quickly in that there was a gentleman out of Minnesota, I believe, this was pre-280E, who was trafficking in cocaine and marijuana. The IRS came after him for not paying his taxes. He had a brilliant legal team, it sounds like, who said, wait a second, we have all of these deductions that we, you know, the baggies, our scales, our gas to drive to California to sell these products. And he got off. And Congress came in and said, that's not okay. We're gonna make it so that you can't deduct ordinary business expenses if you're trafficking. And one of the reasons for that, one of the policy reasons, was to make it almost impossible to operate a viable business and also meet your tax obligations. It was another way to deter people from selling illegal drugs, right? And that is, we were actually just talking before we got online about how that is counter to the policies of states that have decided to legalize, and also counter to the policy of the federal government, who has kind of repeatedly said this is going to be a states' rights issue generally, with some exceptions.
And Hannah, I don't know. That purpose, I don't know if I like that. I think the purpose was to be tough on drugs, and it was in the height of the war on drugs. Everybody was getting on the bus with Nancy Reagan and frying eggs, and you couldn't be tough enough on drugs. It's weird, right, Calvin? We've been dealing with it for close to 15 years now, and it still doesn't make a lot of sense. And there's still a lot of open questions about, okay, if 280E applies, then what? But ultimately, it gets us to a code section called 471. That is a section on what is and is not cost of goods sold in our cases. And Hannah, one thing that's interesting, and then we should probably move on, is Loper, right? A lot of the cases out there that talk about 280E really fall into this category where the IRS has the authority to say what is and is not income in our system, and a lot of that is because of Chevron, and that might be a little bit less the case after Loper and the overruling of Chevron. It's been a really interesting year in the 280E legal space and the cannabis space in general. So we'll see. A lot could be coming up.
Yeah.
I got through that one, Calvin.
Well, I'm sorry, what was that, Nick?
I think we got through that one.
Yeah, I was going to add on one, back to before we move on, you'd mentioned, 280 disallowing deductions, but not disallowing cost of goods sold. And I suppose over a number of years, it was helpful for me to develop the idea that really what 280 disallows deductions, but you still get to recover your basis in anything you sell, whether it's products. You get to recover your basis in your inventory, which that's what cost of goods sold are, basically just a recovery of basis, and reduces your gross receipts to arrive at your gross income. And on a tax return, it's laid out relatively simple. You have your gross receipts, your cost of goods sold, which is recovery of basis, or possibly recovery of basis in a fixed asset. Let's say if you were to liquidate a fixed asset, then it gets to your gross income. All deductions underneath that are disallowed. But that's just, I don't know, I guess I'd throw in there how I've come to think about it. But at any rate, we'll keep moving on. So rescheduling, we should probably talk about that. That's a big topic. Hannah, maybe I'll initially direct this set of questions to you. What has happened so far as part of the pending effort to reschedule cannabis?
Yeah, absolutely. So as Nick mentioned, 280E applies to drugs that fall within the meaning of Schedule 1 and Schedule 2 under the Controlled Substances Act. In 2022, President Biden, through an executive order, initiated a rescheduling process pursuant to the CSA. So basically said, look, things are changing with regard to cannabis. I think we need to look at whether or not it still meets the criteria to be scheduled as a Schedule 1 or 2 drug. The first step in that process under the Controlled Substances Act is for the Department of Health and Human Services to review the most current medical and scientific data and issue a recommendation for whether or not a substance meets a particular schedule. So in this case, in August, September of 2023, a heavily redacted 250-page report was issued by HHS. That report made a recommendation to reschedule cannabis from a Schedule 1 to a Schedule 3. An unredacted version of that report came out in December of 2023. And essentially, one of the most interesting things I think about that report is that as part of every kind of petition process for rescheduling, HHS has to make a recommendation. And there's been a couple of petitions for rescheduling marijuana. And the last one occurred in 2015, 2016. At that time, HHS had recommended that it continue, that had made a finding that cannabis continued to meet the criteria for Schedule 1 and that it should remain on Schedule 1. So in recommending that it no longer met the criteria for Schedule 1, did not meet the criteria for Schedule 2, and should instead be scheduled as a Schedule 3, they had to identify what had changed. Why was their recommendation different? So that was one of the more interesting parts of the report for me. Pursuant to that report, in May of last year, the Department of Justice issued a proposed rule rescheduling cannabis to a Schedule 3, again, consistent with that recommendation. During the summer, they accepted comment. The DEA accepted public comment. That closed in July. They got, I think, around 43,000 comments. And then in response to a request from some stakeholders, they decided to schedule a hearing in front of an administrative law judge to consider kind of more evidence around what the schedule should be. That judge had a scheduling hearing the end of 2024. They had initially scheduled that hearing to occur over 3 days in January. There was some kind of preliminary motion work by parties that had been kind of identified as or authorized to be participants. One of those motions was to essentially disqualify the DEA from the proceedings. The judge denied that motion. The folks who brought that motion requested the ability to kind of appeal that decision. The judge kind of let them know that an appeal would delay the process, but they requested that they be able to appeal. And so in order to give time for the appeal, it's called an interlocutory appeal. It's an appeal that happens kind of in the middle of a proceeding. The hearing itself was stayed, and it stayed indefinitely pending a decision on the appeal. So, we would need, in order for the hearing to start up again, we would need this particular administration to decide that they want to continue with the rescheduling process. We would also need a decision on the appeal, and then we assume, unless they restart the rescheduling process, schedule the hearing, and that the hearing would have to go forward, and there would have to be a recommendation from the administrative law judge before there was a final rule adopted. So with regard to timeline, Nick, I'm really interested to hear kind of what your thinking is on timeline, because there's a lot of variables and spinning plates. I mean, we're kind of internally thinking that, we'll be lucky if we get an administrative hearing scheduled for 2025. And we're probably, if things move smoothly and do progress, we're probably, talking about 2026. But again, I'd be really curious to hear what your thinking is.
I have heard the same thing. And for people that know more about that than I do, it's been a rocky road, right? It doesn't feel like it's following a straight course. And Hannah, I think, the backstory of that chronology that you just gave is the DEA trying to tip the scales toward not rescheduling, right? And it kind of appears like that might be going on. It's scary, right? It's always been a question about, do we really want rescheduling? What does Schedule 3 mean for the industry? And we've talked more about that. And really, okay, 280E goes away if we get to Schedule 3, but we're going to talk more. Maybe 280E already went away. And so, you know, people don't like to hear me say this, but do we really want rescheduling in that situation, right? So I don't know. It's not a priority for the current administration, that's for sure. And you had told me this morning that the appointee for the DEA probably doesn't change that much either.
Yeah, so I think it was so funny. Kelvin and Nick and I were talking before this presentation about, I think we spent about 3 weeks, maybe a month preparing for this presentation. And we have like repeatedly had to go back and add in kind of new information. And I think it was probably about 24 hours ago, Trump announced that he was going to be appointing Terrence Combs, who has been kind of a lifer at the DEA, to the commissioner of DEA. Combs is going to have a lot of power over kind of how this rescheduling proceeding moves forward, if it moves forward. And so we're still kind of trying to digest what that means and read the tea leaves, but that is kind of a new and potentially consequential event. I mean, I think that the reality is that kind of the focus on rescheduling is that there's no question that, at least under the existing language, and we'll talk about this, of 280E, if marijuana cannabis is rescheduled to a Schedule 3, it will no longer be subject to 280E, because 280E only applies, at least under the current language, to Schedule 1 and Schedule 2 substances that fall within Schedule 1 and Schedule 2 within the meaning of the Controlled Substances Act.
Yeah. It would be, we've sort of telegraphed this new change to 280E we're going to talk about a little bit later. But it's what do you think, Hannah? Is it going to happen? Are we going to get rescheduling? Is it real?
So I think the difficult part right now, certainly it's going to depend on this kind of new administration's policy goals. I think we all know that at the end of the campaign, now President Trump made several statements about supporting the rescheduling process, supporting medical use of cannabis, supporting states' rights to legalize cannabis. And so, you know, if you're looking at statements that were made on the campaign trail to try to predict how this administration is going to treat rescheduling, you would say it's likely that the rescheduling process is going to move forward and that it's just a matter of timing. And that timing is a little bit unpredictable, but ultimately we'll likely get to a rescheduling event. It's a little bit more difficult here. Certainly cannabis generally, legalization of cannabis, rescheduling is not a priority of this administration. And so I think that's what we're trying to work through now, particularly with this recent announcement that Terry Combs is going to head the DEA.
Well, I don't know. Is there anything further do you guys think about rescheduling, or should we move on to?
No, I think it's just one of those things to keep an eye on. And actually, Nick and Calvin and I were talking about, like, does it make sense to do like updates have a webinar where we give updates every couple of months, because that's how quickly things are changing. But I think for folks who are interested in tracking it, finding kind of good sources of information, because there are going to be important changes over the next kind of 8 or 9 months that could impact your business one way or the other.
And what about this big bad DEA? Are they trying to tip the scales here? Do you think that's real? I mean, you didn't really focus on that much. You know, when the Attorney General released the proposed rescheduling, that was because DEA said no, right? Which is,
So I mean, it is
said they couldn't decide, is what it says. They couldn't decide whether they wanted to follow HHS, which I think that means they said no. But what do you think? Is it nefarious?
I think that we don't have all the information. I think that so I have a couple of colleagues who are representing folks who are approved to participate. Kelly Fair out of our Oakland office and Joanne Krakus out of our Chicago office. I think that the administrative law judge was being really thoughtful in his decision making, seemed to really understand kind of the narrow scope of the assignment. You know, I don't think I have enough information to make a decision either way. I think I would have liked to have seen the process kind of play out and move forward. But that said, here we are, and I think this is the good segue into the next section. You know, we're in this place now where there's a lot of uncertainty about the time, if nothing else, about the timing for rescheduling. And so in the meantime, what are options for cannabis businesses? What should folks be considering? What are the various positions that folks are taking? What has the IRS said? So I think that's, you know, we're in this place where rescheduling is probably not going to happen in 2025. I could be wrong. I hope I'm proven wrong on that. But it may be 2026. And so as people are thinking about, you know, their 2024 filings and estimated payments for 25, what are their options?
Yeah.
Yeah, it's I guess a great place to move on to, Hannah. So, and I'm sure our listeners are aware that there's a diversity in the approach license holders are taking in regards to how they approach 280E and what they do with it. So, and there's a number of different, let's say, arguments or approaches. And I guess I was thinking next we would maybe walk through the more significant ones. Starting out with Nick, would you care to discuss the argument, Commerce Clause argument, that THC or high THC marijuana is not a, I think really the argument it's not a controlled substance, but I'll let you explore that more if you're willing.
Yeah, it kind of got started when I think it was about 3 years ago or so. Supreme Court Justice Thomas made this statement upon denying cert to another cannabis case that a 2005 U.S. Supreme Court case called Gonzalez v. Raich may no longer be good law. That sort of started a process of examining whether the industry could overturn Gonzalez v. Raich. Gonzalez v. Raich is a 2005 U.S. Supreme Court case, and there was a challenge when California first legalized marijuana. That's who Raich was. To prove that once California legalized it for intra-state use, that it could no longer be regulated under the Interstate Commerce Clause, the U.S. Commerce Clause. Now, back up a little bit. There is no federal power to regulate drugs in the U.S. Constitution. And what the Constitution, 10th Amendment of the Constitution says is any power not specifically given to the federal government in the Constitution is reserved for the states. And so there is nothing about drugs in the Constitution. That's generally comes under police power, which is reserved for the states anyway. And so for that reason, the sort of authority of the federal government is under the Commerce Clause. And the Commerce Clause generally gives the federal government the authority to regulate commerce that flows between states or in the avenues of interstate commercial waterways and freeways and stuff like that. And here, our cannabis industry is not interstate. Our cannabis industry is a bunch of separate intra-state markets and industries. And so Raich sued, went all the way up to the Supreme Court. And what the Supreme Court basically said, they lost. What the Supreme Court basically said is that because the federal government at that time, 2005, had a policy of eliminating marijuana from the United States. You might recall that in the early days of California legalization, they were locking people up. In fact, that's what kind of happened to Raich. They had their plants cut down and all that. So the court basically said that because of this interstate and national policy of eliminating this evil product from our dear country, that because of that, it was necessary and proper then for the federal government to also regulate marijuana in California's intra-market. Basically, they said we couldn't give California an exception to this nationwide policy because it would really evaporate that policy if we gave California, if we couldn't enforce the Controlled Substances Act in California. So what Justice Thomas said is that key fact is no longer true. And do we have a little background noise on there? That key fact is no longer true. That national policy, that the interstate policy and need that was necessary then to not allow California to regulate its own intrastate program, that is no longer true, because the three main things that show that are the federal government's own actions. So that's the Cole memos, which were Department of Justice memos saying that marijuana was very low priority, and basically they weren't going to interfere with the legalized state-approved marijuana programs. The Cole memos came out early on. I think the first one wasn't called Cole then, but I think it was 2009. I think it was pretty early. Yeah. And then a little later on, I think it was 14 or 15, we start getting these Rohrabacher-Farr amendments that are budget riders that restrict the Department of Justice's ability to spend any money in prosecuting people who are engaging in state legalized marijuana conduct. And then the third one, that government's own actions or inaction, as the case may be, was the authorization or the failure to not authorize Washington, D.C.'s program. The U.S. government had the ability to stop Washington, D.C. from legalizing marijuana for medical use, and it didn't do that. So those are the kind of the three main factors that show that the federal government now has what I call a hands-off approach, rather than this approach to eliminate marijuana from the United States. And that started the process of getting a group of cannabis companies together to go ahead and challenge the federal government. And that happened in 2023 in a case called Canna Provisions. And that involves plaintiffs Canna Provisions, Gaia C. Sellers, Wiseacre Farm, and Verano Holdings. That case was filed and right about the same time that Trulieve made their announcement that they were taking the position that 280E no longer applied beginning in 2019, and filed amended returns and asked for their 280E tax dollars back. Trulieve then announced about 3 months later that it got $150 million. Hannah, that really started the rumor mill, right? Because what Trulieve said is that they were taking the position was their quote secret sauce, and so nobody really knew what was going on there. But they saw they got all that money, right? And so everybody's talking, right? And so there were a lot of talk out there about what this was. Was it the Farm Bill? Was it the rescheduling? Was it kind of, what is it, right? And it caused the industry to do a lot of speculation out there, and that started the process. Interestingly, that started things going. Other companies started taking the positions, other public companies making announcements, doing those kind of things. And then in the summer of last year, we got an IRS notice that came out. And it was interesting, Calvin, that IRS notice basically said that companies filing amended returns, according to the position that rescheduling will be retroactive and other positions, are wrong, basically. Those returns, they called them invalid, I think, in that announcement. But 2 days later, that was on June 28th of 2024. I think that was like a Friday maybe, or a Thursday. And then on Monday or Tuesday of the following week, we get a decision in Canna Provisions, the case that is the Commerce Clause case. And the court basically says in that decision, in order is what it really is that overturning a Supreme Court case is not in their power. They can't do that. They're bound by the Supreme Court's determination. But we're going to have to dismiss your case, and you can go on up and appeal and get to the Supreme Court where they could give you the relief that you're looking for. But Hannah, they actually specifically said that the argument that the plaintiffs brought was, quote, persuasive. That was kind of a big moment, particularly with the IRS issuing that notice. It's scary. And then the next thing we know, here's this sort of, validation a little bit of the position in Canna Provisions that a lot of us were relying on to help our clients. That then took the case out of the district court. They then filed a notice of appeal. The U.S. Appeals Court then fast-tracked Canna Provisions straight to oral arguments, which were held on, I believe, December 5th of last year. And that's where we are. We're expecting an opinion out of the appeals court any day. The law firm handling that case is called Boyce Schiller Flexner. They tell me that, you know, it could be just another rubber stamp like the district court issued, or perhaps a more reasoned opinion of some sort. I think the longer it takes, the more likely it is a more reasoned opinion of some kind. So that's the interstate commerce clause argument. You know, the moral of the story is if it wins, marijuana is no longer a controlled substance in those states that have legalized marijuana for intrastate use. And, you know, a lot of times when my bigger clients, then the question is, well, Nick, can we then start moving it from California into selling it in Arkansas? And the answer is no. That is the interstate commerce clause, right? But if it's no longer a controlled substance under the Controlled Substances Act, then Section 280E should not apply.
Right, that part of the argument really is saying, you know, Reich was based on kind of this marijuana industry generally. It captured both the illicit trade, which is over state lines, as well as the legal cannabis industry, which is intrastate commerce. You need to peel those apart. So even if there is a finding that these state legal programs no longer are intrastate, and so not subject to the Congress's ability to regulate under the Commerce Clause, that doesn't mean that folks who are operating in the illicit industry, shipping stuff over state lines, are not subject to 280E or the Controlled Substances Act.
Which is one of the fears as well. And I note that the lawyers for Canada Provisions have said that again and again, because they don't want the court to think that ruling in their favor would basically get rid of the Controlled Substances Act, right? So yeah, very, very good point. It's a fun fight, right? You know, it could win. You know, Hannah and myself and other lawyers like us have been trying to advise our clients, and Calvin as well, that, you know, we need to protect our ability to benefit should it win. We'll talk a little bit about tax opinions and disclosures and stuff like that, which is kind of the way you do that in our system. But Hannah, it's been a little exciting for the last year and a half or so, I think. A little better than the bad news that is Section 471A and full absorption accounting and all that fun stuff for cannabis businesses.
Well, it's so funny. I was just thinking about how when you were talking about the Cannabis Provisions decision dropping on December 5th, the scheduling hearing was scheduled December 2nd. So like you have all of these kind of interrelated moving parts that are impacting each other, and they're happening kind of in real time. These changes are happening. It's a full-time job to kind of monitor and keep up with everything that's going on.
You know, and Hannah, right at the same time that IRS announcement came out and then the Cannabis Provisions order came out, a case called Moore was decided by the U.S. Supreme Court as well, which maybe gives a little bit of oomph to the argument that Section 280 is unconstitutional under the 16th Amendment. Maybe we'll see. It was suggestive that some judges might think that. So it's moving fast. Things are really moving fast.
Well, Nick, thanks for what I guess I'd characterize pretty detailed discussion regarding one of the, let's say, bigger pieces of arguments that 280 doesn't apply to marijuana. Maybe another approach or that's different is a timing of rescheduling, maybe for lack of a better term. And Hannah, could you talk a little bit about that particular argument?
Yeah, absolutely. I'm happy to. So like that argument is it's a statutory argument. And so it looks at the language of 280E itself, which Nick read to us at the beginning. So again, 280E applies to businesses and individuals who are trafficking in a controlled substance within the meaning of Schedule 1 or Schedule 2 of the Controlled Substances Act. And so the way that the argument goes is that each of these scheduled drugs has criteria that you have to meet in order for it to be Schedule 1 within the meaning of the CSA, Schedule 2 within the meaning of the CSA, all the way down to Schedule 5. And that those are really based on factual circumstances, not the process of rescheduling itself, that 280E doesn't cross-reference the schedules, doesn't say when a final rule is adopted to reschedule, doesn't say Schedule 1 as listed on the schedules of the CSA. Instead, the language that Congress chose was within the meaning. And so when you look at specifically the HHS report, they went through and evaluated kind of what had changed between 2015 and 2016 when they said, nope, based on the medical and scientific data that we've reviewed, cannabis still meets the criteria for Schedule 1 and should remain Schedule 1. And 2023, when they said it no longer meets the criteria for Schedule 1, we don't think it meets the criteria for Schedule 2. Instead, based on these things that happened between 2016 and 2023, and I think the most important things really happened kind of pre-2019, cannabis no longer meets the criteria under the CSA for Schedule 1 or Schedule 2. It meets the criteria for a Schedule 3 drug. And so the argument is that, you know, yes, you're going to have this administrative process that you have to go through to reschedule, which we've seen has a unpredictable timeline, can be influenced by politics, but that really what Congress intended was that when a substance no longer met those criteria, it would no longer be subject to 280E. And so I think the position is pointing to HHS's own analysis and things that they identified as happening between 2016 and 2023 that 280E no longer applies to marijuana. So it really is this timing argument. So that's that argument in a nutshell.
You know, I was going to ask this. It kind of seemed maybe the reason that the Congress wrote the language that way within the meeting is it seems like a two-edged sword, and would give. Let's say there was a substance that was not yet on the Controlled Substances Act, but should be or will be soon, and was, you know, a dangerous substance. Then that would give them flexibility to say, oh, this isn't on a controlled substance Schedule 1, Schedule 2 yet, but it should be, it would be, and it will be. So 280 applies to that. So my point being that this flexibility should be used to potentially say something still is on, but it's really going away and it practically is gone. And on the other side, something is not on the controlled substances list yet, but is and should be. I don't know if that makes sense.
It is the case that, you know, there is an argument that within the meaning was intended to give the IRS that has the authority and the jurisdiction to interpret 280E. Who does 280E apply to? Who does it not apply to? They don't have jurisdiction to interpret the Controlled Substances Act necessarily, but they do have authority to interpret and apply the Internal Revenue Code, that it would give them flexibility in the event there was some substance that hadn't yet been listed, but the people agreed was high potential for addiction, didn't have any medical benefit, was dangerous, posed a public health and safety issue, and take the position that 280E applied. So it is the case that in some ways the IRS taking the position that there has to be a final rule adopted, which could be many, many years after. You know, really, if you look at the HHS report, again, it's 2018 seems to be the year in which they think that changed. If we get rescheduling in 2026, that means 8 years would have gone by, 9 years would have gone by, 8 years would have gone by between this substance no longer qualifying, meeting the criteria factually for a Schedule 1 or Schedule 2, and the actual rescheduling happening, the rule being adopted. And it does seem that that particular interpretation would take discretion and the ability to be a little bit more flexible in the application of 280E away from the IRS.
And that 2000 change then, that's about whether there is a sort of a state consensus that there is a currently accepted medical use for marijuana. That was, maybe there's a little more nuance.
There's a little bit,
which was what was also criticized about the 2016 denial, right? That they used the wrong test to determine whether or not there was a CAMU. Help us understand that a little bit more.
Yeah, I mean, absolutely. They identified a number of things. They looked at all the data, but they also pointed to the FDA approval of Epidiolex, which is a marijuana-derived drug that was approved by the FDA. It's hemp-derived, but cannabis sativa L. They talked about the Farm Bill, carving out hemp, which is a subset, or, it's cannabis sativa L that meets certain other criteria, from the definition of marijuana. So it kind of holistically, it was, we have all this new data. We have data from states. States have accepted this data showing that there's medical benefit, but we also have the FDA approving a drug that is derived from cannabis sativa L that supports a position that there's medical benefit.
Do we need the new, so that's a really interesting distinction, because that would mean that the new test that recognizes that the state's experience could be sufficient to establish a currently accepted medical use. Those are two different things, right? Epidiolex approval is not that new test. That is an actual approval of a marijuana-derived drug that should have met the original test.
Yes. Yeah. So I think people are one of the primary criticisms of the HHS report is that it changes the test, right? It changes the standard. I think that there is an argument that what they have identified would have meets the new standard that they focused on, but arguably would also satisfy the previously used standard.
Mm-hmm.
All right. I was going to say
that I'm such a
so I guess from my perspective, wrong or right, I've always looked at, these are the two main compelling arguments that 280 doesn't apply currently and for some time in the past. I guess my question, are there other supplemental arguments, maybe is what I'd characterize them? 16th Amendment or 8th Amendment arguments that, like I said, maybe supplement either or both of these arguments?
I'll take the 16th if you want.
yeah.
So 16th Amendment is the amendment to the U.S. Constitution that authorized our income tax. And the term income, it's kind of old man to do this now, isn't it? The term income is a defined term, and it's been defined by the courts as gain. So that our income tax then taxes gain. And those of you in the industry know full well that at the end of the year, you pay tax on more than your gain. And Hannah, I like to represent it like this. Let's say I'm the cannabis company and I buy a joint from Calvin for $2. Calvin grows the best weed in town. And Hannah is my bud tenderess, and she cost me $2 also. And then she manages to sell this joint for $5. Margins are pretty thin in the cannabis industry right now, right? So I made $1, but because of 280E, I pay tax on $3, right? So is that gain? Am I paying tax on my gain? Is that constitutional under the 16th Amendment? So that argument has been brought forth in the courts in a case called Patients Mutual. It's sort of the most informed case on that position, but it hasn't made it up to the Supreme Court yet. So it still is kind of undecided. If you're in the tax court, they're going to laugh at you at an argument that 280 may be unconstitutional. But the Ninth Circuit in Patients Mutual stated that the issue was moot, was not at issue. And so they did not rule on the argument that 280E is unconstitutional under the 16th Amendment. Calvin, it could be. I have another theory, and it's that this as well, and it's another one of these theories that's out there that 280 is constitutional, but the costs that can't be deducted get to be carried forward. They're not permanently erased. They're still ordinary and necessary business expenses, but once you give credit to the cost of the goods, and when you're taxing the sale of the goods, the gain has been satisfied, and these other costs aren't directly tied to income yet, and so we can disallow the deduction of them. But they're still there. They're still there. They should get carried forward, and we may get to a point where the law realizes they are available in some other way other than deductions. And then I'll just say I mentioned this earlier, this case Moore came out right about the same time that the Cannabis Provisions Order came out. Moore is a U.S. Supreme Court case that involved a new rule that said that individual U.S. owners of foreign corporations that had undistributed income could be taxed according to their ownership interest in that foreign corporation. And the Moores challenged that, saying it was unconstitutional under the 16th Amendment because it taxed more than income and amounts that were not realized. And we thought we might get an opinion out of that case that would directly impact Section 280E. The majority opinion kind of punted on the question of income, and they assumed that income and realization was recognized and was in fact established because the company realized the income. And really the question was just, does the Congress have the authority to then attribute that income to an individual owner rather than the company? So it didn't really get into all the nitty gritty on income and gain that we'd like to see the court rule on. But 4 justices didn't like that issue was not addressed and wrote separate opinions, 1 concurring opinion and 1 dissent, basically saying that realization and income was a constitutional requirement. And 2 of them agreed it was satisfied, but wanted to make that point, and 2 of them said it was not satisfied because the owners didn't actually receive the income. So that's the kind of the 16th Amendment fight. I think, Hannah, if a company is going to take the no 280E position, these positions aren't one or the other, right? You need to protect yourself on all the positions. One of them could end up being relevant when the others are not. In fact, the 16th Amendment position could become extremely important if this change to 280E occurs that we're going to talk about after we talk about the 8th Amendment.
Yeah, I'll just quickly say that there are some other kind of, it's our understanding that there are other positions taken. One is an 8th Amendment position that 280E violates the prohibition on excessive fees or penalties. I think there's a THCA argument out there. And I just think it's important to highlight kind of that there is a spectrum of arguments, a number of arguments out there when we kind of talk about what the IRS has come out and said. And I agree, Nick, it's my understanding. So I'm a cannabis lawyer. I'm not a tax lawyer. I work very closely with our tax team. But it's my understanding that if you do not raise kind of the basis for your positions during your statute of limitations, you could be foreclosed from taking that position if you end up having to defend it. And so it is really important. We're about to talk about tax opinions and reasonable basis. It's critically important that you have a reasonable basis, that you're working with legal counsel and CPAs to make sure you're checking that box. But also you want to make sure that you are kind of capturing all of the arguments so that you're not foreclosed in the future from taking that position.
Hannah, that THCA argument is really interesting, isn't it? That's kind of the hemp farm bill. And I asked a lot of people out there in the industry about, have you tested your marijuana? Is it just THCA? And I got all kinds of different answers. What do you think about that one? I mean, and I think the other interesting thing is, because of that, there's hemp-derived THC products in almost every state where marijuana remains illegal. You can go out and buy a soda that has a lot of fun in it, right? So what do you think?
I think ultimately internally we could not get to reasonable basis on. It doesn't mean that there isn't potentially a reasonable basis. It's just we've taken a very conservative approach in our thinking about this, I think, and we couldn't get there with THCA, the THCA agreement. But we are running out of time because there's so much exciting stuff to talk about. But I think the next piece is pretty important.
Yeah, and that's really kind of an extension of this conversation around tax opinions. Why, and maybe I'll say it this way: why is it a good idea to get a tax opinion? And we've started talking about this, and maybe we can explore it more, Nick. Why is it a good idea to get a tax opinion? And what is a tax opinion? And yeah, that's probably a good starting point for the question, if that makes sense.
Yeah, so first off, there's two different things, right? And Hannah's going to talk about disclosures. Those are two different documents, right? You've got an opinion that goes in your file, and you've got a disclosure that goes on your tax return, okay? The opinion is probably a lot longer than the disclosure, right? Um, but I think, Calvin, I think opinions got a little more important after the IRS announcement last month or in December, right? The IRS announced in December that it was looking at disclosures and for that cannabis companies were filing, and some of them were insufficient. Um, and I think that makes opinions more important, right? These are tricky, nuanced arguments, and with the support of a lawyer writing an opinion, you can point at it and go, "Hey, wait a minute, I did it this the right way, right?" And our system recognizes that we should be able to take positions that turn out wrong if we do it in the right way. And an opinion, it would appear at this point, is one of those things you do. The way it generally works is, let's say you get audited. Let's say the IRS says no, and it says, "Oh, we think you're wrong, we think you're subject to a penalty. What do you think?" Well, you point to CANA provisions and you say, "Wait, the court said that was persuasive. What do you mean?" And you try to do that. But what if they disagree with you? What if they think the position is frivolous? Now you've got an opinion. You say, "Look, here's this opinion. It's 900 pages long. This really old lawyer wrote it. They were very qualified, et cetera, et cetera, et cetera." And maybe that does it, right? And then they agree that opinion establishes that the position is reasonable and that there is reasonable basis there. Reasonable basis is, say, Hannah, I would say it's about 20 to 40%, somewhere in that range. The IRS doesn't like us to talk numbers, I don't think, on that stuff, though. It's not a science. Even, and then there's one more step, actually. If this is why a big firm like Dentons or Greenspoon Marder is important. Even if that opinion, they don't like that opinion, IRS says, goes, "Oh, no, I don't think I did it. I don't think it did it." You can still say, "Well, okay, I still relied on a qualified professional, and for that reason, I still shouldn't be penalized if it in fact turns out to be wrong." So like I said, it's part of our system. Our system recognizes that the IRS might get it wrong, and it affords this pathway to take a position that could be wrong, or that the IRS could disagree with it and not be subject to the negligence and substantial understatement penalties that add up to about 40%.
I think it's really important here just to emphasize that while there are options that cannabis businesses should be considering, it is critically important that you be understanding the risks. There's risks associated with all of these positions. It is really important that you're working with a CPA team and a legal team that has both cannabis and either accounting or tax experience, and that you, before making a decision internally as a company to take a particular position, really understand those risks and have kicked the tires. Because like Nick said, if you're doing it right, you're exercising diligence. And part of that is putting together the right kind of legal and accounting team, tax team, but also you yourself kind of understanding the issues. And so that is something that, we're talking about this stuff at a very high level, but anybody who's interested should really kind of make sure that they're doing due diligence separate and apart from this webinar. And maybe that's doesn't need to be stated, but I just want to caution people that there is risk here. You need to understand that risk and make the decision, an educated decision, for what's best for your business.
It's one of the other things that the IRS notices focus on amended returns, which is interesting. I wonder if you think there's more risk in going back than going forward.
I'm not sure, right? I think that that if they're going to reject the position, they're going to reject the position both on original returns and on amended returns, right? And so I understand that they've been focusing on the language appears to focus on amended returns, but I'm not sure. I mean, I think I'm not sure. And I also actually think it's really dependent on your individual tax filing history, positions that you've taken historically, how aggressive have you been around 280E? You know, do you want past years to be opened up? Do you want to just take it going forward? So I really think it's a very fact-based analysis, and it really kind of depends on what the company has done in previous years, and it requires a kind of a deep dive into that.
Yeah. And I'll say, Calvin, it's 3 years. You can go back 3 years, right? Once you file the original return, you have 3 years to file an amended return, which I think means that probably 2021 is as far back as you could go now from
Yep.
this company.
I'm gonna just before we move off the tax opinions, I'll group this together, tax opinions and disclosure conversation. Before we move off though, I want to boil it down to a question as a tax preparer that I get a lot of times from clients who are considering this. And we've talked a lot about risk. What are the risks? And as Hannah said, this is something you need to explore yourself with qualified professionals. But I'm going to boil it down to a question where it's like, well, what are the risks? And I respond often, the risks are that you're not successful in this. The IRS for sure would, if you're not successful, you'd have to pay the tax, and you would have to for sure pay interest on that tax. Then we get to the question of penalties and how I respond. And maybe this is a question whether you agree with this response is you get the tax opinion and make the disclosures to mitigate your risk or reduce your risk that you'll have penalties, and maybe even reduce and mitigate your risk significantly. But nonetheless, you're still not completely eliminating the risk that you could end up paying penalties. Would you agree with that characterization generally?
Yeah, I think our position is that it provides a defense to penalties. You can't kind of dictate what the IRS is going to do, but you can do your diligence, work with the right team, get a tax opinion, do your disclosures, and that will provide a defense.
Well, excellent. Maybe one more quick thing around this area, Hannah, protective claims, which is really using the same arguments, but as opposed to, let's say, asking for refunds on amended returns or taking a position in what it means for paying tax or asking for refunds, you file amended returns, holding the statute as a avenue to, while not currently saving cash, leaving you the opportunity to in the future to amend your returns and ask for cash later. I guess that's my interpretation of a protective claim. Would you have any further comments?
Yeah, it's basically it protects your right to pursue a refund outside the statute of limitations based on a contingency event. I think the thing that I'll highlight for folks is, it's my understanding, not as a tax lawyer, as a cannabis lawyer, that usually when you're filing a protective claim, you have a case that you're pointing to. So if this taxpayer who's in tax court wins, then I'm going to have a right to a refund for this reason. And if that taxpayer wins, if they settle, you're out of luck. If they lose, you're out of luck. But if they win, you're able to kind of pursue those amended returns, refunds pursuant to amended returns based on that position. We don't have a case right now necessarily. I mean, that may be changing that we can point to. And so there is some risk where you could say, look, I filed this protective refund claim and the IRS says, but you didn't identify clearly enough kind of the contingency. And so it's just being really thoughtful about how you're drafting those to make sure that you are including kind of specific enough contingencies and enough information so that you could defend against that position by the IRS in the future.
Yeah, I agree with that. And like, what if they find in Cannabis provisions that a company like that they lose because a company like Verano is involved that's in multiple states, right? Where does that leave a guy who's just has a dispensary here in Denver, right? That shouldn't apply to them, right? So, and if you're tied to that case and all you have is a protective claim, you just lost.
We'll move on to, we've talked a lot about what's going on in industry and some of the positions that people are taking and how they're approaching 280. What I was hoping to do is also discuss how the IRS has reacted to some of these positions, because we know in some of this we actually discussed a little bit before, so maybe the conversation will be shorter. But we know in two different instances during 2024, the IRS has communicated or issued communications that relate to some of these things. I'll just bring them up, and like I said, some of this we've started to touch on earlier. But Hannah, back in June, the IRS issued a notice. Just want to briefly talk about what it said and what it potentially means.
Yeah, essentially the IRS came out and said it is our position that 280E continues to apply until a final rule rescheduling, actually moving cannabis from Schedule 1 to Schedule 3 is adopted. So we had kind of anticipated that that was going to be the IRS's position. You know, we disagree with the IRS on that interpretation. As we talked about before, there's nothing in the language of 280E that even cross-references the schedules themselves. But I think the other thing that happened on June 28th, and this was referenced really quickly, or by Nick at the beginning, was Loper Bright. And so we're now in a position where if we do find ourselves challenging the IRS's position under, there's a lot of nuance to this, but with Chevron gone, Chevron saying if an agency's interpretation is reasonable, it's entitled to deference. Now courts are directed to interpret the law, pick the best interpretation. And that I think puts, that is really helpful. The Loper Bright decision was helpful. I think on June 28th, we kicked the tires hard and felt like with Loper, we came out ahead.
Yeah. Hey, Calvin, I'll add.
Oh, go ahead.
I'll add, this is not our topic today, but Loper's good for 471C as well.
Yep, absolutely. Definitely in probably a further conversation, maybe at some point.
Mm-hmm.
Nick, maybe you could speak briefly to the fact sheet that the IRS issued, or if there's any additional comments that we haven't made. The fact sheet the IRS issued in December 2024.
Yeah, they kind of announced I think they called it a special project or something like that. It was a couple different things in there. The ERC was in there, and one of the things that they said was that they had reviewed disclosures filed by cannabis companies, and that some of those disclosures were insufficient. They were not. A disclosure has to be adequate, and you can't get over something that's wrong, right, with a disclosure. And they sort of said that you can't remedy a false position by disclosing. And it's really, I think it turns up the volume on these disclosures. Mine are going to get longer. And look, they're really trying to cast a wide net here too, right? Their language is so broad, it's hard to really kind of see what they're really getting at sometimes. Their focus on rescheduling in the first one and other positions, and it's just, they seem really schizophrenic. I'll say this, Calvin, I haven't seen any real organized program from the IRS yet or anything like that, like the task forces that we saw here in Colorado in 2016, 17, 18. I haven't seen anything like that around this.
I know over time, but I was just gonna say, I mean, we think importantly that it references some disclosures, and there is this direction at the end to say, look, if you're gonna take a tax position that you feel like you need to disclose, make sure you're working with legal counsel, make sure you're working with a CPA firm that really understands this stuff. So that was, those 2 points we viewed as important.
Yeah.
No, that's a great point. Nick and Hannah, as Hannah mentioned, we're already over time. I guess I'll leave it up to you guys. Let's say there was one additional topic we were going to cover. Would you guys like to try to take a couple minutes to explore that, or should we call her quits? Okay. Just really briefly, in Actually, earlier this month, were a couple senators that introduced a piece of legislation. And if my understanding is correct, that this legislation, if passed by both chambers, which at this point is just only introduced, emphasize that would disallow deductions for businesses trafficking in marijuana without regard to whether it was a Schedule 1, Schedule 2, or Schedule 3 controlled substance. That's at least kind of my interpretation of this newly introduced piece of legislation. I guess I'll throw this out there to both of you. Two questions. Did you have any additional comments or even corrections to my understanding? And then secondly, to the extent you're interested, would either one of you want to be willing to venture a guess to whether this had any likelihood of ever becoming law?
So you're right, Calvin. What the introduced legislation would do is it would amend the language of 280E to just say that if you're trafficking in a Schedule 1 drug or a Schedule 2 drug within the meaning of the CSA or marijuana, just generally, then you wouldn't be able to deduct ordinary business expenses or take tax credits. Interestingly, it's introduced by I think it's a senator, not a representative, from Oklahoma and one from Nebraska. Oklahoma has a robust legal industry. It's so hard to tell, but my sense is that there now are so many states and so many senators and representatives who have legal marijuana businesses in their districts, who have medical marijuana patients, who rely on access to safe legal marijuana, that, because of the impact of 280E on these businesses, that, the path to passage may be a difficult one. But in addition to that, again, we talked about how on the campaign trail, President Trump supported rescheduling. And so, he would have to sign this understanding that the impact to 280E. So it's in very early stages. It's concerning that it's been introduced, but there's a long path that has to travel between now and it potentially becoming law.
Yeah, that makes a lot of sense. I don't know, Nick, do you anything further beyond that?
I would say it goes beyond concerning to be straight out offensive. It would be the worst of worlds if we went to Schedule 3 and it didn't make 280E go away, right? So it's pretty brutal. It would make the main two arguments, the timing, the rescheduling argument, and the canon provisions arguments no longer work.
Yep.
And then it would leave, where we were before that, which is 16th Amendment 471C for small business taxpayers. So it's a big dagger. And the way they're marketing it, it's, you can see that it'll get good attention. They're calling it the "Don't Give Marijuana Companies a Tax Break" bill or something like that, or don't make American taxpayers fund the cannabis industry bill. And that'll get some people's attention.
Yeah, that makes sense. Well, we've already tied up 10 more minutes of your guys' time than what we had agreed to. So I guess maybe this is a good time to wrap it up. But again, I want to express my appreciation to you guys for having this discussion, and obviously to all the listeners who joined in. It was a great discussion, and I know I've learned a lot. But Hannah and Nick, I'll let you guys both sign off, and otherwise, again, I appreciate it.
Thanks, Calvin. Really good to work with you and Hannah and as well. Great information here. Really excited to be part of this, and I think doing the update in a month or two would be a great idea.
Yeah, me as well.
I agree. It's an absolute pleasure to be able to present with Calvin and Nick, who are kind of thought leaders in this industry, and I'm happy to be on a panel with both of you. And again, there's a lot going on. We really encourage people to be following it closely and choosing the right professionals to kind of guide their decision making. And again, Calvin, thank you so much for the invitation to be part of this panel.
You bet. We appreciate you guys joining us. Y'all have a great afternoon.
Thank you.
Thank you.
Thanks, bye.